Hi there everyone. Welcome to the presentation on HIPAA and the privacy regulations for IBT personnel. This presentation provides a brief summary about federal rules governing the privacy of health information, and it defines basic terms and lists basic principles that all IBT personnel must follow in regards to the HIPAA privacy rule. In this presentation, you will learn what HIPAA is, the basics of the privacy rule, how HIPAA privacy affects each of us, the consequences of non-compliance with HIPAA privacy rules, and where to go with questions regarding HIPAA. First, we need to cover what HIPAA actually is. HIPAA is an acronym that stands for Health Insurance Portability and Accountability Act of 1996. HIPAA is a federal law that establishes uniform rules for protecting health information and privacy. It should also be noted that any law that you have locally that is stricter than HIPAA and is more protective of health information privacy than HIPAA is still applies. So what that means is there may be laws in your specific area, let's say Arkansas for example, that has laws regarding health information protection and transfer that are stricter than HIPAA. In those instances, you must follow the law of the land, which is more strict than HIPAA. So some basics of the HIPAA privacy rule. IBT personnel cannot see or use protected health information unless it is required for the job. IBT personnel can only see or use the minimum amount of protected health information that is necessary for a task. IBT personnel who see or use protected health information in violation of HIPAA have violated federal law. Penalties for this can include fines, jail, and IBT disciplinary actions, which may include termination or expulsion. So all of this means that you will only be permitted to see as much information as is minimally necessary for you to complete a job that you need to do with a client or at the office. So here is a list of some examples of some consequences that may occur if you violate the HIPAA privacy rules. You could accrue a $100 fine per day for each standard violation, up to $25,000 per person per year per standard. You could have a $50,000 fine and up to 1 year in prison for improperly obtaining or disclosing health information. A $100,000 fine and up to 5 years in prison for obtaining or disclosing health information under false pretenses. A $250,000 fine and up to 10 years in prison for obtaining health information with the intent to sell, transfer, or use for commercial advantage, personal gain, or harm. And then you could also have penalties under IBT's policy, which can include termination or expulsion. You have to follow HIPAA rules. If you do not, the consequences are severe. It is a federal law. Who needs to comply with these privacy rules? All IBT personnel, including clinical teams, administrative staff, students, volunteers, and any other related personnel associated with IB teams who see or use protected health information, have to follow these rules. This can include consultants, supervisors, direct service providers, respite providers, personal assistants, research assistants, and ancillary supports, such as family adjustment counselors, speech therapists, etc. Anyone working at IBT has to follow these rules, regardless of whether you work with the kiddos as a direct service provider or consultant, or in the office as administrative staff. You will probably come into contact with some form of protected health information at some point. Therefore, you need to follow HIPAA rules. So I've thrown around the term protected health information a little bit throughout this presentation, but we have not covered what it actually is yet. So, protected health information comes from the treatment plan, a healthcare provider, or a health plan. It identifies an individual, or could be used to identify an individual. It describes the healthcare condition or payments of an individual or describes the demographics of an individual. It is identifying information that could be used to trace back to an individual. Some examples of things that are protected health information include zip code, address, birth date, email address, account number that you might have with different organizations, IP addresses, full face photos, anything that can be used to identify a person. And it's really relevant that you understand this because in a small town, there are other things that aren't listed on here that could be used as unique identifying characteristics to trace back to a person or a person's family. Whenever you live in a very small town or you work in a small town, you have to be very, very careful about information that you share, because what might not be considered personal health information or identifying characteristics in a town, say the size of Raleigh, North Carolina, which is a fairly large town, could be used as identifying information in a town, say the size of Manhattan, Kansas, which is not very big. It is quite small and it is very close-knit, and a lot of people know each other. You have to be very careful with it. So, protected health information describes a health condition. It can be information from a healthcare provider or health plan, information about an individual's physical or mental condition, including their past history, present condition, or plans or predictions about the future of a condition. Protected health information also describes healthcare. It is information from a healthcare provider or health plan about an individual's healthcare, including who provided care, what type of care was given, where the care was given, when the care was given, and why the care was given. Protected health information describes healthcare payments that a people or an individual could have made. It is information from a healthcare provider or health plan about an individual's healthcare payments, including who was paid, what services were covered by the payment, where payment was made, when payment was made, and how payment was made. Protected health information must be secured in all forms. So, all of that information that was just presented as protected health information has to be secured either for storage purposes or for transmitting purposes, because we work on a lot of multidisciplinary teams, which means that we will have to transfer information. So, written information must be secured. Oral communications must be secured, and any electronic communications must be secured. Written information is usually somewhere blocked away, has all the identifiers taken off that can be taken off. It is protected in that only certain people can access it, things like that. Electronic information is secured through the use of encryption software, closed systems, and any other electronic protections, firewalls, passwords, so on and so forth. It's the oral communication that is probably the trickiest to secure, which is why it's in bold here, because oral communication includes phone calls, meetings, informal conversations, etc., that as someone who works with people, you are likely to have. You are likely to have a phone call between consultants asking about particulars on cases that they're on at team meetings. You're likely to have informal conversations with parents about things with their child, or informal conversations between staff on treatment teams, etc., etc. And these are the ones that we have to really watch out for, because, like I said earlier, whenever you're working in a small town, things that you might not think can be used as identifying information actually can be. So some ways that we secure our oral communications are we use initials instead of names. We don't talk about diagnoses, especially whenever we're out in public in the community. We don't talk about other families whenever we're out in the community or with our clients and things, and we take every precaution that we can to make sure that if we are having oral communications, no one can listen in on our communications and think, oh, they're describing little Jimmy that I know. Things like that. So now that we've discussed what protected health information is and how we transmit it, we need to talk about when can IBT personnel use this protected health information, because we do need to have access to it to a degree depending on your job and your tasks, and we do need to use it. So we can only use it when authorized by the administrative staff for care coordination, or when the individual has signed a valid authorization form, or as specifically permitted or required by law. So we can only use it whenever we have the proper signatures, the proper paperwork, and the proper permission. Otherwise, we cannot use it. In all cases, we have to use reasonable security measures to safeguard protected health information, which will be covered in the next slide. So, reasonable security measures for protected health information. Under HIPAA, there are specific requirements that are listed as reasonable security measures. Those are the measures that any organization or persons using protected health information must follow as the bare bones minimum to be in compliance with HIPAA law. So, in a couple slides back, we had oral communication in very bold text. So, what I'm going to cover on this slide are some of those reasonable security measures for transmitting oral communications about our clients and their cases. So this includes but is not limited to: do not talk about clients outside the treatment team. So don't go home to your partner or your spouse or your roommate or your friend and say, you know, I was working with little Jimmy today and he did really great and I'm so proud of him. Don't do that. Do not share information about other clients with treatment team. So do not talk about your client that you have down the road with people who are not involved with the client down the road. Do not talk about the client's family to anyone in the community. Don't talk about the client with your pastor. Don't talk about them with your sports coach. Don't do it. Only talk about client care coordination in a secure location away from anyone not directly on the client's team. Now, this one's a little bit tricky because IBT currently only has an office in one location, and then we have the kids' place. Aside from that, we don't really have anywhere that IBT owns, operates, rents, leases, whatever, where we can go if we live in, say, Lenexa or Manhattan or any other place that is only staffed with IBT personnel and that has secure rooms and stuff. So this one can get a little bit tricky. So when discussion is pertinent to continuity of care, we need to remove all identifying information and only refer to the individual by initials only, which is generally what happens whenever you need to discuss a client with someone while you are out and about, not necessarily in the most secure of locations. For example, here in Manhattan, we use the public library quite often as an office base, sort of, and we try to find a room or an area that doesn't have anyone in it, that is away from people who are nearby. And whenever we do talk about clients, we use initials. I personally only use their first name initial just to be extra safe. So for electronic information, we have things like use and do not share computer passwords with anyone. If you live in a household where you have a shared computer, don't put personal health information on that computer. You need to put it somewhere else where only you can access it, where it is password protected. And just to be safe, it probably needs to be double password protected, meaning that to get into your computer there is a password, and to access those specific files there is a password. You can Google how to password protect certain files if you're unsure about how to do that. You should lock doors, lock file cabinets, and limit access to workspace where health information is used or stored, both in its physical written form and in its electronic form. You should limit access to printers and faxes where health information is printed. Probably not a good idea to print things that have personal health information on them in a public space, such as a library. You should limit access to health information to only those who need it for a specific task. So you shouldn't show team member so-and-so information for someone that they're not on, and you shouldn't show them all of the health information of the client that you're showing them. You should only limit it to what they need to see or know. You should redact or use de-identified health information whenever possible. So redaction, if you have those classified documents from the government, you see that they have these big black bars over things, that's redaction. Or you should try to de-identify that health information, so removing names, using some sort of software, or using whiteout, something like that. You should shred or otherwise properly dispose of health information trash. So whenever you do shred or dispose of it, you have to be careful, because depending on the size of the things that have been shredded, people might be able to piece them together. And there are services where you can shred documents and then have those service people come and pick it up, and they'll dispose of it in a secure way. You should definitely ask wherever you are if you are using a shredder, if they have that service. If not, probably don't shred it there. You should use and keep only the minimum health information necessary for a specific task. So you probably shouldn't print out a client's entire medical history and then keep it in a lockbox, because you probably don't need all of that health information if you have access to it to do your specific task. Only keep the bare minimum of what you need. And you should follow all privacy policies and procedures that have been listed out in IBT's manual. So, in wrapping up here about privacy, you need to keep protected health information private and secure at all times. Passwords, encryptions, locks, all of those good things. Make sure only IBT personnel who need to use protected health information see it, hear it, or use it. No one else should see it, hear it, or use it. And you should only use the minimum amount of protected health information necessary to accomplish the task. You must read and understand IBT's privacy policies and procedures. If you read those, then you should be in the clear, and you should understand what it is that we expect of you. And you should consult your privacy official with any questions you have about privacy or protected health information. So, now we're going to do a little bit of knowledge testing. So because I can't hear you or see you, and you can't see me because this is a recording, I'm going to ask you, I'm going to pause, I want you to answer it in your head or out loud or however you do these things, and then on the next slide I'll show you what the correct answer is. So, true or false? HIPAA has replaced all Kansas laws about privacy of health information. If you said false, then you are correct. You should follow Kansas law in cases where Kansas law is stricter and more protective of privacy than HIPAA. Always follow the strictest form of the law. All right. When are IBT personnel authorized to use protected health information? If you said C, then you are correct. IBT personnel may only see or use protected health information when it is required for a specific job, and they can only see the bare minimum necessary. Violation of HIPAA privacy rules can result in which of the following penalties? If you said D, you are correct. All of the above. Violation of HIPAA privacy rules can result in a fine, in a jail sentence, and IBT discipline, including termination or expulsion from the company. And then our last one, protected health information comes from a healthcare provider or a health plan and includes If you said D, then you are correct. All of the above. Protected health information comes from a healthcare provider or a health plan and includes all of the items listed, including information about a condition, information about payments, and demographic information. So, some next steps. Some IBT personnel will receive additional training about privacy that is designed to address a specific job or activity. Questions about HIPAA, privacy rules, so on and so forth, can be addressed to the privacy official in your region or administrative division, or to the IBT privacy official, which is Dr. Linda Heitzman Powell. Her email is right there on the bottom. So if you want to take a moment to write that down, put it somewhere secure, I will give you one. Alright, so that is the end of the HIPAA presentation. What you will need to do is you will need to go onto the Google Classroom. There will be a separate document that has this signature page on it as a PDF. You will need to print 2 copies of this slide, sign and date below. 1 copy will be placed in your employee file at IBT. There will be a digital copy of it in your Google Drive folder. And the other is for you to keep for your records. I personally suggest keeping not only the physical copy somewhere secure, but also keeping a couple electronic copies somewhere that are also secure, so say on your computer, which is password protected like we talked about. And because this doesn't include any personal health information, you could keep it in, say, a Dropbox, a Google Drive, somewhere like that. Just somewhere safe so that if anything happens to your physical computer, you still have access to it. So you'll need to read the statement there below, sign where it says employee, put the date on it, and then the person obtaining your signature will also sign it, they will date it, and then it will go to the IBT staff. So if you have any questions, please feel free to post them on the Google Classroom, or if there are specific questions about HIPAA, you can email Dr. Heitzman Powell like we had on the previous slides. It had her email and things like that. And then whenever you're done viewing this presentation, please go and take the IBT HIPAA post test as well. Thanks. Hey there everyone, welcome to